Hey, good day to you. This is Stan Prochowski with Prochowski Estate Law, and this is the Ask Stan show every Thursday at 12 noon, where I answer all your estate planning questions submitted throughout the week. If you have a question about wills, trusts, Medicaid pre-planning, Medicaid crisis planning, the nursing home, or just estate planning in general, just send them to me here on Facebook or call me at 363-7222 or email me at prochowskiestatelaw@gmail.com. I'll answer them live on WKSR Radio, and we post them here on the Ask Stan show every Thursday. So, let's get right to it.
Stan Prochowski, oldie of the week this morning, going with an instrumental this morning.
That's right. That's my DJ in training, right? That's the tornado.
That's all right.
or does it say around here, tornadoes?
But you bring a different one to the table every week.
I try.
I'll give you that. Yeah. All right.
Hey, I want to talk a little bit. We talked about my seminar, and I'll talk about that at the end of the session. But I want to talk a little bit about some stories. We like to tell stories about estate planning because we can learn from those. And these are ones that have come to my office in one form or another. It's kind of based on what happens, what are the kind of things that can happen if you procrastinate and put this off and fail to plan or do poor planning, or in some cases do it yourself. So I want to talk about a couple of things. I had a situation where I had a surviving spouse, her husband passed away, came to me under the impression that they had done their trust and their other documents, and it was all set and ready to go, and they had done it with a LegalZoom. I'm not here to bash LegalZoom. I mean, they produce a product, but what they don't produce is the follow-up service that goes with it. So I didn't. The trust was probably drafted okay, but anyway, LegalZoom sent them this really nice zippered binder. I've seen those. They're pretty classy. They're kind of nice. Put your stuff in. They look good on the shelf. But what happened was these folks they never unzipped it and never opened it. They never signed the documents because they were done remotely and sent to them. And they thought, okay, we got a trust. Didn't sign it. So when the husband died, they wound up having to go to probate for one of the properties that was inherited to him from his family. So that was a piece of separate property. So it, of course, had to go through probate.
Sounds like the do-it-yourself approach to planning is to try and save some money. Is that the reason people try that?
Well, I'm sure it is. And if you look at this case, if it's not done right, all that, they didn't save anything at all because now they're out the cost of the do-it-yourself planning, and now they find themselves into the probate process anyway, which is what the planning was supposed to avoid. And so you end up with really the worst of both worlds that way. So, you think you're saving money, but usually it doesn't. Another LegalZoom story is, having a trust drafted, but then you don't have any legal guidance to fund the trust, which means you move your property, into the trust. Those folks that we just talked about had a trust with nothing in it. Everything had to go through probate. So, in my firm, we've got a unique way to make sure that these problems never happen to our trust clients. So we have a funding coordinator, Miss Alex, and she makes sure all your property gets put into the trust. We continually follow up with you and make sure that gets done. It's that important. And that's what was missing in this case. So we make sure that doesn't happen. Another story was, had a gentleman, a while back, he said he was worried about being sued. He was in business and something went wrong. He was afraid he was going to be sued. So he had the idea that he signed a quitclaim deed to transfer his family home to his wife, and as her sole and separate property. Well, it turned out he didn't get sued, or it got settled, never really quite went to court, but he never put the property back into their names as joint tenants like it was in the first place. Mm-hmm. His wife suddenly died, and now he found himself in the middle of probate trying to get back his own home. Now, the first mistake here is, if you think you're going to get sued, when I say think you're going to get sued, I don't mean like, I'm worried 10 years from now I'll get sued. If something's in the wind and you suspect, general inquiry notice or general due diligence tells you something's wrong and you may have somebody out there wanting to sue you, you should never transfer assets to try to hide them. Because what that does is it triggers what's called the Fraudulent Conveyance Act. So the real simple, that's got some pretty harsh penalties if you do that. So the simple solution would have been just pretty much do the exact same thing, set up the quitclaim deed, but instead of giving it to the wife or to the spouse, put it into an asset protection trust. That protects it from all lawsuits and all creditors.
All right, so Stan, let me go back here. So let me get this straight. It was his home. He gave it to his wife, and now after her death, he wants it back.
You know, that's right. And think of it this way. In this case, the wife died with the home in her name, right? So if it's in her name, off the probate, you got to go, right? So husband's in probate. I can hear it. I can hear it now. The husband's in probate court. He's on the witness stand, and he's asked the question, why do you say the home is yours when you deeded it to your spouse? And his answer is, well, I didn't want the lawsuit to take it, but now I'm not worried about the lawsuit anymore, and I want it back. So, I mean, talk about what, you know, having it both ways. It just doesn't work that way. So that could have been done a lot better. Another one, this one's terrible. I mean, this is just terrible. You get a couple that gets into a pretty big fight, and the husband runs off, and he's kicked off, and he goes and does a trust, but he doesn't mention in trust that he's married in those documents. Then after a few years later, he passes away, and of course they had reconciled. You know, they got back together again, but you know, the wife was omitted from all the documents, so she had to file a lawsuit against her sister-in-law to rightfully gain back her joint property assets that she had, that he had put in the trust when he was mad, when he was angry. And what I saw from this one was the lawsuit that the wife had to deal with. She was in the neighborhood of $50,000 in attorney's fees.
Well, that just sounds like a bad idea, don't you
You know, I hate to say it this way, but that was just stupidity on the part of the husband. But you know, I don't want to put the blame on him too much, because, in my opinion, it was absolutely malpractice on the part of the attorney who drafted this plan for the husband that excluded the wife. Now, you've often heard me say here that in the state of Tennessee, you can disinherit your kids. I mean, you can do that as much as you want, but you can't disinherit a spouse. I mean, we have laws against that. A surviving spouse enjoys the legal rights to joint property, and you can't take it away in a trust or a will or a handwritten document. I mean, it's called elective share, and these are here to protect spouses from that very kind of abuse. So, I mean, just like in this case, if you get disinherited and you want to exercise your rights to elective share, you can do that, but you have to go to court to do it, and court's what we were trying to prevent in the first place. So anyway, these are all stories of tragedy, either by planning, poor planning, or do-it-yourself planning. And you know, I've said before on do-it-yourself, you know, anything in the law you can pretty much do yourself if you want to, including defend yourself against a murder charge. Just not always a real good idea, because if you make a mistake, you can't cry inexperience. You know, you can't say, well, I'm not an attorney, I wasn't sure, I didn't go to law school, and I didn't know how to do that, so I should get some forgiveness for doing it wrong. You don't get that benefit. So those are some of the things. And at Prochowski Estate Law and Elder Law, I mean, this is what we do. This is what we do every day, and this is what we do. That's only what we do. So you know, if you're thinking about doing a plan, or you hadn't done a plan, or you've been putting a plan off, or you know, even thinking about a do-it-yourself plan, you know, at least come and talk to me. We'll discuss the issues. We'll talk about your own family dynamics, and we'll see what needs to be done. If you still want to do a do-it-yourself plan, I mean, at least you'll be doing it with, you know, informed. It'd be an informed decision. But that's one of the things we talk about. We talk about wills, trusts, and the nursing home at my seminar coming up. Doing it live, back to live seminars. Doing one on May the 6th, which is a Thursday. Going to do it at 1 o'clock in the afternoon, then again at 6, like we usually do. That first one on the 6th is over at your sister station, WLX in Lawrenceburg, right on the main drag there. In the back of the building, they have the Country Cafe. It's a nice venue. They dance there on Friday night. It's got a ton of room. So we got plenty of room to spread out if we need to. It's a great venue. So if you want to come, just call the office and RSVP to that. Or the following Thursday, which is the 13th. I'm going to do it here in town. I'm going to do it at the Star Theater, where we have plenty of room to spread out again. So the 13th, going to do it the same way. 1 o'clock in the afternoon, and a second one at 6 p.m. Okay. So it's called the Wills, Trust, and the Nursing Home, and those are the things we're going to talk about. It lasts about an hour, and then we stick around and answer questions as long as you need me to. I'll be sticking around until midnight and answer questions if you got ones to ask. So don't leave there uninformed. That's what it's for. It's free, it's educational, it's no obligation. Even be a little bit of food there if Miss Tammy has her way. So, come on, it'd be interesting. Bring your questions with you, ask them, put me to the challenge. Make me make me answer your questions and leave there informed about this. And you know, if you want to do something, come see us and we'll get it done.
All right, Stan Perchowski Estate Law, your contact information.
Sure, just call me at the office over there at the southeast side of the square. The number's 931-363-7222. Call me, talk to me, Miss Alex, Miss Tammy, or Miss Courtney, and we'll get you scheduled and discuss your family dynamics.
All right, Stan. Thank you, sir.
Oh,
Appreciate that. Good to have you this morning. We'll take a short break. We've got